Good morning, one and all present in this webinar. Education is the passport to the future, for tomorrow belongs to those who prepare for it today. Malcolm S. Honorable Speaker and resource persons of the day, respected Principal, respected Chairman, and respected CEO, sir, dear faculties, staff, students, ladies and gentlemen. It gives me an immense pleasure to extend a warm welcome to all of you on behalf of Soundarya College of Law. I would also like to express our gratitude to our esteemed speaker of the day, Dr. OMPRAKASH, Principal in Charge and Associate Professor, Ramaiah College of Law, Bengaluru, who has accepted our invitation to address us in this webinar on anti-defection law under Indian Constitution. I welcome you, sir. Soundarya College of Law, established in the year 2017, is providing quality education as well as exposure to its students in different fields of law. It is extremely gratifying that the college has reached new heights. In this process, a great initiative taken by our principal, Dr. B.P. Mahesha, is introduction of this webinar series to enlighten all of us with brainstorming sessions on various topics of law. It is a pleasure for me to welcome you, sir, to this webinar series. Inspirations of a visionary like our chairman, Sri Soundarya P. Manjappa, and young and dynamic CEO, Sir Sri Kirtan sir, SET is always paying us with great results. My hearty welcome to both of you, sir, to this webinar series. I extend my warm welcome to all the faculties, staff, and my dear students for today's webinar. I expect that the webinar will be productive and fruitful to all of us. Thank you very much, sir, for welcoming. Now, I introduce the speaker for this today, webinar series number 2, Dr. OMPRAKASH, currently working as Principal in Charge and Associate Professor in Ramaiah College of Law, Bengaluru. Basically, I am an engineering graduate, obtained his bachelor's degree in mechanical engineering at BIT, Bengaluru with first class distinction, bachelor's degree in law at Seshadripuram Law College, master's degree in law at University Law College, Bengaluru, PhD in the area of constitutional law on the topic impact of anti-defection law on democratic institutions in India, a critical study from Alliance University, qualified UGC Junior Research Fellowship for Researcher exam, qualified Karnataka State Eligibility Test for Lectureship exams. His academic achievements are secured first rank and 3 gold medals in LLB, awarded with Justice B. Vasudeva Murthy Gold Medal for securing highest marks in Hindu law, awarded with Pradhana Shiromani Nyayapati Madhava Rao Gold Medal for securing highest marks in BA LLB, awarded with Professor T. Shivashankar Gold Medal for securing highest marks in LLB and first rank holder in LLM. His work experience are as like this: worked as a quality control engineer in small scale industry, worked as a lecturer at Seshadripuram Law College, Bengaluru, worked as assistant professor in M.S. Ramaiah Law College and elevated as assistant professor senior in M.S. Ramaiah Law College. Now currently working as principal in charge and associate professor in Ramaiah Law College. Various positions have been assumed by during his academic and his experience. Governing Council member at Ramaiah. Yes. participated in hearing the views on the ongoing political situation in Karnataka with Prajavani, a leading Kannada print media. Participated in debates in public TV, a reported Kannada news channel. His various experiences in committees like facilitator or coordinator for bridge courses and certificate programs, chief editor for college annual magazine, Legalia, worked as a chief editor for biannual newsletter named Sadhana. His reserve publications are like this: Women Reservation Bill will be a reality, published in Karnataka Civil and Criminal Reporter. Judicial Interpretation on Anti-Defection Law, a review published in Journal of Emerging Technologies and Innovative Research, Institute International Journal, a UGC recognized journal. Anti-Defection Laws applicable to local authorities, a study with special reference to Karnataka, published in Alamin Law Journal.
And you can
Power of
shut the profile editing, I think.
Complete justice under Article 142 of Constitution. He has attended various moot court competitions, paper presentations, seminars, workshops and conferences at various platforms. He also faculty development program coordinator and developed various certification programs. He has published the books Judicial Dictate on Anti-Defection Law, and few are under review: The Glory of Lord Balarama and Ekadashi and its observance. Such a great academician, researcher and an administrator has accepted our invitation to address our students on anti-defection law under Indian Constitution. It is a great pleasure to have you with us for this webinar series, sir. Once again, a warm welcome to you. Over to you, sir.
Thank you. Thank you. So let me place on record my sincere gratitude and thanks for giving this opportunity to the principal, BP Mahesh sir, my very good friend. I should place on record my gratitude to all the faculty members of Soundarya College of Law, Sri Kirtan Kumar, the CEO of Soundarya Educational Trust. It's an opportunity to hear the views on the subject as well. As pointed out, education is always a process of learning. Now, in a quick span of 1 hour duration, I think the first 45 minutes I will take you around to what the anti-defection law is all about. And then 10 minutes can be taken for answering any questions posed by the listeners. Now, to start with, as you all know, with the topic for today, anti-defection law, I should go back and give you the history why this law came into force. What was the need for this law? Now, when I speak about anti-defection law, as you all know, remember defection. What do you mean by defection? The very first question which answers is, what is defection? Now, as all of you know, defection generally means to join an opposite group by abandoning a present association. Now, in other countries, it is also called by the term crossing of floor. Now, people, when they get elected representatives, after getting elected, keep switching on sides from one political party to another political party. Maybe from opposition side to government, from government to opposition, or vice versa. Now, elected member of a parliament or a member of a state legislature assembly, when he switches side from one political party to another political party, it constitutes defection. Now, if you look into the elections held to the parliament after independence of the country, till 1967, fourth general elections, correct? In 1967, till 1967, the most of the people who contested elections were freedom fighters who had a particular ideology. Any political party at that point of time, I tell you, even though there was monopoly of the Congress government. Now, to tell you frankly, I don't belong to any political party. As a constitutional teacher, I may give you certain examples which may be connected to, case laws, which have arisen in various states. So I may give you examples of Congress MLAs defecting. I may give you examples of BJP MLAs defecting. But let me make it very clear, I don't belong to any political party. And I'm giving my views just as a student of law, as a student of the constitutional law. Now, till the fourth general election, as I told you, the major parties at that point of time, those people who contested elections were freedom fighters who fought for the independence of the country. They had certain ideologies. They had played a vital role in the freedom struggle of the country. Now, party ideology and affinity towards one political party was strictly adhered to by the elected members. Now, later, money became the sole consideration. Sole consideration was money. People gave importance to power, position, privileges attached to such office, lure of office. Okay, people started to switch sides from one political party to another political party. Now, after the fourth general elections, if you look into the statistics, the data collected, how many people defected. Now, that's what I told you. Till 1967, for a period of, from the first general election to the fourth general election, people were attached to party ideologies. Most of these people never looked at money. What they looked at is ideology. These were the people who fought for the development of the country. Development of the country, what I meant was who were the contributors to the freedom struggle. Now, later, these defections became an evil. Now, to combat this evil of political defections, in 1967, December 8th, 1967, if I recall, a unanimous resolution was passed to bring in, there is a necessity to constitute committee on defections. Now, when I say committee on defections, the committee on defections had representations from all political parties at that point of time. Unanimous decision was taken that there should be a committee on defections. A committee should be constituted to suggest what are the remedial measures to come out of, these defections, which is become an evil concern for the nation. Now, later on, the era of coalition governments, 2-3 political parties coming together to form government became common. Now, political defections, I tell you, happened because of the ideologies associated with the political party. Its members who had contested elections, who had got elected from that political party, maybe one of the reasons of not accepting ideologies. The second reason may be lure of office, power, position, money attached to such office. Therefore, people started defecting from one political party to another political party. Now, defections after 1967, if you look into the statistics, out of the 210 members who defected after winning from one political party and then joining another political party, out of 210, 116 of them were made cabinet ministers. When I say these statistics, I am referring to the report submitted, the report which was looked into by the Committee on Defections. So therefore, I am quoting the numbers taken directly from such report, where it is mentioned that out of 210 people who defected, 116 of them were made cabinet ministers. Therefore, if you look into this, one point is very clear that lure of office, power, position, enjoyment of such powers and privileges attached to such office, people started defecting from one political party to another. Now, formation of new governments by 2-3 political parties coming together became a common practice. When 2-3 coalition political parties come together to form a government, as you all know, the party ideologies generally of one political party does not match with other. But to form a government, to enjoy the benefits attached to such office, people started forming coalition governments. Now, when coalition governments were formed, coalition governments, as all of you know, did not stay together for a long time. Different affinity towards political parties, different party ideologies, all together, contributed to defections. Stability of the government was also a big concern. Therefore, stability, without proper stability of a government, it also hampered the economic development of the country. New governments, formation of new governments, toppling existing governments formed, and then bringing in new governments became a common practice. Now, the Committee on Defections looked into the overall statistics of the people defected. So therefore, in a short gap from March 1968, if you look into, the committee studied all this in the period of 1 year, 2 years data, and they came up with what remedial measures can be taken to tackle defections. Now, this is the background history of why defections law, to curb this defections law, was a necessity. Now, always the students of law should always know that any law brought, if you look into the preamble of the law, the preamble gives you a clear intention of the framers why this law was brought. Now, if you look into this particular anti-defection law, it makes it very clear to combat this evil of political defections, which have become a matter of national concern, it says. Therefore, this was the intention of the legislature, that there is a need to tackle defections. Therefore, the anti-defection law, also called the 10th schedule of the Constitution of India, which is part and parcel of the syllabus of Karnataka State Law University Constitutional Law 2 as well. Generally in questions related to short note and anti-defection law, being a contemporary issue relevant, is always been asked in the examination as well. Now, when I make this lecture, when I'm delivering this lecture, I'm also of the opinion that anti-defection law, even though it's a contemporary issue, at the same time, it will help the students who are studying constitutional law too under the Karnataka State Law University as well. Now, as I told you, political instability was leading to hampering the economic development of the country, was getting hampered. Now, how this 10th schedule was inserted. Now, all of you know, now Article 102 subclass 2 and Article 191 subclass 2 of the Constitution of India narrates the various points under which a members of parliament and state legislatures can be disqualified. Now, so there was a provision which was inserted, the 52nd Amendment 1985. Please note, 52nd Amendment 1985, okay, called the Anti-Defection law, was inserted under the 10th schedule. So Article 102 subclass 2 and Article 191 subclass 2 contained a provision which says, as disqualified under the 10th schedule of the Constitution. There are other factors, as all of you know. A person, if he is insolvent, as all of you know, he is having an office of profit, all those. Therefore, this disqualification provision was also added to Article 102 subclass 2 and Article 191 subclass 2. Now what happened later? Horse trading, corruption became a common practice in government formation. Now, government formation requires a lot of compromises and understanding. Now, at the same time, if you look into the preamble of the Constitution, as all of you know, a democratic setup is given due importance. Correct? So forming a government, if it enjoys majority of the members of the parliament, correct, then a government can be formed. Correct? Therefore, in a democratic setup, defections have to be curtailed. At the same time, dissent, there is a thin difference between dissent and defection. All dissent cannot be taken as defection, but unprincipled dissent has to be taken as defection. This thin margin between dissent and defection has always led to many various cases before the high courts and Supreme Court. Now, every member of a political party may not agree to join hands, correct, to form a government by bringing in 2-3 political parties to form a coalition government. There comes the differences. Now, therefore, political defections do happen in a democratic setup, but it has to be as well respected at the same time. Dissent is very essential in a democracy, but unprincipled dissent should be curtailed. Now, the most important which we have to look into right now is understanding the constitutional provisions of the anti-defection law. Now, I have given you the history why this law was inserted. I told you the intention of the legislature, what it was, to combat the evil of political defections, which was a concern of the nation, national concern. Therefore, this law was put in the 10th schedule of the Constitution of India. Now, after the law has been brought, now before I go into what happened after the law, let me give you some 10 provisions with respect to the anti-defection law and the Constitution of India. Now, see, the law, anti-defection law, contains total overall 8 paragraphs. Now, paragraph 2 is the complete basis of interpretation for which legal tussle generally happen, whether the disqualification made by the speaker is correct or whether it is not correct. All those legal tussle is interpreted by the judiciary looking into the paragraph 2. Now, let me highlight 2 important provisions under paragraph 2, under the 10th schedule of the Constitution. Now, paragraph 2 mentions disqualification on ground of defection. So, what are the grounds of defection is mentioned in paragraph 2. Now, what is the first point which the law says is a member of a house belonging to any political party shall be disqualified for being a member of the house if he has voluntarily given up his membership of such political party. So let me repeat, the entire crux of the anti-defection law completely rests with paragraph 2 being interpreted by the judiciary. Now, paragraph 2 contains 2 provisions. One is paragraph 2(1)(a). The second is paragraph 2(1)(b). So what is paragraph 2(1)(a)? It says any member belonging to any political party shall be disqualified for being a member of the house if he has voluntarily given up his membership of such political party. Now, when you say voluntarily given up membership of such political party, whether voluntarily giving up membership should be in a written format. Say, for example, after winning on a party ticket, I am elected as an elected representative. My conduct and behavior should be very clear to showcase that I am having affinity towards one political party. Correct? So paragraph 2(1)(a) says any member elected from a political party ticket can be disqualified by the speaker if he has voluntarily given up his membership of the political party. Now, the voluntarily giving up membership was interpreted by the Supreme Court in Ravi S. Nayak case. The case happened in Goa in 1994. The Supreme Court in Ravi S. Nayak versus Union of India made it very clear that voluntarily giving up membership need not be expressed by giving resignation. It can be implied by the conduct of the political party's member, elected representative. You understand? Therefore, what is important is the crux to be understood is voluntarily giving up of membership can be decided by the speaker that he has voluntarily given up the membership of the political party by which he was elected to the parliament or the legislative assembly of any state on ground of that by his conduct he has given up voluntarily his membership of the political party. There are two things. One is a person may resign from the political party membership as well as resign for being a member of the house. But he may not resign, but his conduct may be such that he is behaving in a manner which is not conducive to the political party. In such cases, when a complaint is filed before the speaker if a complaint is filed under paragraph 2(1)(a) that he has voluntarily given up his membership of the political party, then the speaker will express in his order that he is disqualified under paragraph 2(1)(a) of the 10th schedule of the Constitution of India. Now, the second is 2(1)(b) says, as all of you know already, that when voting takes place inside the parliament or a state legislative assembly, if a member elected representative votes or abstains from voting in such a house contrary to the directions issued by the political party to which he belongs or by any person or authority authorized by it in this behalf without obtaining in either case the prior permission of such political party, person or authority, and such voting or abstention has not been condoned by such political party, person or authority within 15 days from the date of such voting or abstention. Now, in brief, let me summarize in brief what does paragraph 2(1)(b) of the law say. Now, paragraph 2(1)(b) says, if you look into closely, if you read the terms, the words used in paragraph 2(1)(b), it is very clear that if a person votes contrary to the directions issued by the political party, that is why these days, as all of you know, political party issues whips when crucial voting has to be done. Say, for example, vote of confidence is tabled in the house today. Whip is issued to all its members to make sure that when you vote, you please follow the directions given in that whip. The party would have given you certain diktats, certain directions, what you have to do. So you have to do it accordingly what the party has told in the whip. And it will also be mentioned as the Supreme Court has interpreted in various other case laws. Now, the whip should also include very clearly the consequences of violating the whip issued. If you vote contrary to the directions issued by the political party, then it becomes a ground for disqualifying you by filing a petition before the speaker. Therefore, now this is the first part of this paragraph 2(1)(b). If you look into the other part of paragraph 2(1)(b), it also says that even if you have violated against the whip issued, the party can condone your conduct within 15 days. I made a mistake. Say, for example, I am an elected representative. For example, I am an elected representative. I do not vote according to the party's directions, as mentioned in the whip, but contrary to the directions issued, I cast my vote. Still, the party can condone your behavior. Correct? Therefore, there are two important grounds. One is voluntarily giving up membership. Voluntarily giving up membership may not be by in an expressed format of resignation. The second is it can also be implied by the conduct of the behavior of such member of political party being an elected representative. Now, the second is you vote contrary to the directions given by the party, then it is a ground for disqualification. At the same time, the dissent which you have done against the party can also be condoned. Your behavior can be condoned by the political party if it wishes to do so within 15 days. Therefore, there exist two options. You have to, so the clear understanding is very clear. You have to obey party directions, obey party whips. If you violate party whip, it is a ground for the party to file a complaint by the chief whip to the speaker saying such and such person should be disqualified from the membership of the house. Now, these are the two important grounds under which a member can be disqualified. Now, the next is you may get a question with doubt with respect to what is the case of a independent member. A person elected as a member of the house on an independent, contesting as an independent without contesting as a representative of any political party. Now, the law is very clear. If you look into paragraph 2, subclass 2 of the Anti-Deflection law, 10th schedule of the Constitution of India, it makes it very clear that an elected member of a house who has been elected as such otherwise than as a candidate set up by the political party shall be disqualified for being a member of the house if he joins any political party after such election. Therefore, the law is very clear. If an independent member wins as an independent without contesting on ticket of any political party and he is elected as an independent by the voters, in such case, he should remain as independent member itself. The day you give it in writing, the day your conduct, the behavior is such that you have shown affinity towards a political party, there exists, you are creating the ground for disqualification. Therefore, during the tenure of that particular house, legislature of that particular term of the house, you should remain as an independent without joining any political party. Now, I know you may get various questions with respect to this, which I will be answering at a later point of time. Now, what about nominated member? Correct? As you all know, a nominated government has power to nominate members, right? Now, a nominated member of a house shall be disqualified for being a member of the house if he joins any political party after the expiry of 6 months from the date on which he takes seat. Correct? Now, therefore, a nominated member, a person nominated by the government, should, if he wants to join a political party, any political party, he should immediately make it very clear within the first 6 months that he wishes to join this political party. It will not result in disqualification. But a nominated member, after 6 months, if he joins any political party, then the ground for disqualification, he has attracted the grounds for disqualification. Any person, any member of the house can file a complaint before the speaker and say he has violated such and such provisions of the anti-defection law, therefore he should be disqualified. So I have made position very clear with respect to what are the grounds of defection under paragraph 2. One is voluntarily giving up membership. The second is if you vote contrary or abstain from voting. See, there are two things. One is you are present in the house, but you vote contrary to the directions issued by the political party. The second is on a crucial day of vote of confidence, you have to be present, but you abstain from coming to the house. Both are punishable. Therefore, it attracts paragraph 2. In such cases, a complaint can be filed before the speaker. So I have made you very clear with respect to the grounds of disqualification as narrated under paragraph 2 of the schedule. Now, what is the position with respect to an independent member? Independent member should always remain independent. Once he shows his affinity towards a political party, his supporting a government as an independent member is altogether different, which the Supreme Court has made it very clear. The Supreme Court has made it very clear. Now, But when you are elected as an independent, when the people have elected you and wishes to see you as an independent member, you should remain independent during that particular tenure of the House. A nominated member, what is the scene? A nominated member can join any political party because generally nominated members are appointed by the government. They do appoint their members. There is nothing wrong. In such cases, they have to make sure that they join a political party, whichever political party wishes to join after getting nominated, fulfilling all the requirements of the oath taking as provided under Article 99 or Article 188 of the Constitution of India. He can join a political party within the first 6 months. But if he decides to be a nominated member for the full tenure, he can do so. But if he joins after 6 months to any political party, there exists, he attracts the grounds of disqualification. Now, this is with respect to independent member, nominated member, and an elected member from a political party ticket. Now, paragraph 3, which is now removed, but still I will mention it for your understanding. Paragraph 3 speaks with respect to disqualification provisions mentioned under paragraph 2 shall not be applicable in case if there is a split. Now, this provision is taken over by the 91st Amendment Act in 2003, where it made it very clear that if there is a split in a political party, if 1/3 of the members form a separate group, in such cases, disqualification is not attracted under paragraph 2. Now, similarly, if you look into paragraph 4, it speaks about merger. What is merger? One political party merging with another political party, which is a common, these days. Disqualification on ground of defection not to apply in case of merger. Therefore, paragraph 4 makes it very clear that a member belonging to a political party shall not be disqualified, as the case may be, if a new political party is formed where 2 more political parties join together. Merger of 2 political parties and forming a new political party, or 2/3 of the members of a political party form a separate group and join another political party. In such cases, this is an exception to paragraph 2. Therefore, it does not attract disqualification at all. If at all, there are 2/3 of the members are of the view that they should form a separate group. Now, what is paragraph 5 of the law, Anti-Defection under the Constitution of India? It makes it very clear, paragraph 5, that the exemption is provided under paragraph 5 to the Speaker. The Speaker of a House, being a constitutional authority, after getting elected to such high dignitary office, should behave in such a way that he is impartial in his conduct, in conducting the House functions. In such cases, if he wishes to, after getting elected to such high dignitary office of the Speaker, if the such person, after getting elected as Speaker, if he wants to voluntarily give up the membership of the political party to which he was associated before getting elected as Speaker, there is an exception. Correct? Means to say, this provision is very clear that the Speaker, Deputy Speaker of the House, or the Chairman, Deputy Chairman of a Legislative Council, either the case may be, being the reason for his elevation to such high office, if he voluntarily gives up the membership of the political party to which he belonged before getting elected to the Speaker, in such cases, he should be excused. Correct? Therefore, but there is a provision also granted to him. After demitting his office as Speaker, he can join his political party back. In such cases, it does not attract the provisions of disqualification on ground of defection. Now, paragraph 6 of the law says where disqualification application has to be filed, to whom it has to be filed, who will decide the disqualification application. Paragraph 6 makes it very clear that any question arises as to whether a member of a house has become subject to disqualification under the 10th schedule of the Constitution of India, the question shall be referred for the decision of the chairman or the case may be the speaker of such house, and his decision shall be final. Now, please look into the last sentence used in the law. It says his decision shall be final. Now, there is a protection clause which was used under 6 subclass 2, which says that all proceedings under this paragraph, any disqualification of a member of a house under this schedule shall be deemed to be proceedings in the parliament within the meaning of Article 122, as the case may be Article 212. Now, what do you mean by Article 122? What is 212? If you look into it, says court should not interfere into the proceedings of the legislature. Correct? 122 speaks with the proceedings of the parliament. Now 212 speaks with the proceedings of the state legislature. So there is an ambit bar used saying court should not interfere with the proceedings of the legislature. Now, question of the paragraph 7 of the anti-defection law makes it very clear with respect to the bar of jurisdiction of courts. Now, as all of you know, this particular law says that no court shall have any jurisdiction in respect of any matter connected with the disqualification of a member of a house under this schedule. Means to say, the paragraph 7 is taking the jurisdiction of courts. It's taking away the jurisdiction of courts, making it very clear no court shall entertain, have jurisdiction to look into any disqualification of a member of a house made under this schedule. Now, paragraph 8 gives provisions to make rules for the operation of this particular law. The speaker of various houses, okay, since this law was made by the parliament, rules being a subordinate legislation can be made up by individual houses of state legislature. Now, this provision was made under Rule 8 of the Anti-Defection law. Now, after this Anti-Defection law was passed, I tell you, the question next exists was the constitutional validity of this law was challenged before the Supreme Court. The constitutional validity of the law was challenged before the Supreme Court. On what grounds? You may ask me, what are the grounds? The grounds for challenging the constitutional validity of this particular anti-defection law was, first, it violates the principles of natural justice. Now, when I say the principles of natural justice, you may ask me a question, what is meant by principles of natural justice? I'm not going in detail to that, but let me tell you, the speaker is also an elected member of the house. One member out of the total members elected in the house shall be elected to the office of such high dignitary post, the speaker of the house, being a constitutional authority. Now, the speaker, you remember the principles of natural, first principle is no man should be judged in his own cause. Now, being the speaker, if the government falls down, the speaker will also lose his chair. Therefore, there exists conflict of interest as well. The continuance of the office as speaker of such house depends on the majority of the house. If the government falls down, which enjoys majority in the house, automatically the speaker will also lose his chair. Therefore, disqualification applications when filed before the speaker of the house, is it not violating the principles of natural justice, because the speaker also has a conflict of interest when he decides a matter. This was also an argument which was made before the Supreme Court. Okay. The case law Quixote Olan in the year 1992 was the first case where the constitutional validity of this law was challenged before the Supreme Court. Constitutional bench at the matter, Justice Venkatachalaya, who headed the bench. Now, by majority, the Supreme Court applied the doctrine of severability, as all of you know. Now, paragraph 7, which takes over the jurisdiction of courts, was struck down as unconstitutional on the ground that judicial review is the basic feature of the Constitution. Judicial review being the basic feature of the Constitution was already told by the Supreme Court in the year 1973, as all of you know, by the Supreme Court in the famous case like Keshavananda Bharati versus State of Kerala. A 13-judge bench of the Supreme Court made it very clear that judicial review is a basic feature of the Constitution. The court only there said that the basic features should not be amended. Now, what are basic features? Judicial review is a basic feature which should be there. Judiciary being the guardian of the constitution, the apex court of the country. If you look into the anti-defection law, the paragraph 7 said no court. When you say no court, you are ousting the jurisdiction of all courts in the country. Therefore, paragraph 7 was struck down by the Supreme Court as unconstitutional on the ground of violating the basic feature being judicial review, being the basic feature. Now, therefore, the court said the doctrine of severability was applied. Paragraph 7 was struck down. It was removed from the anti-defection law, but the remaining provisions continued, and the law validity, the validity of this particular, the constitutional validity of this law was upheld. Only the paragraph which was unconstitutional was set aside. Now, this is the crux, the provisions under which the anti-defection law works. Now, the legal tussle when matter goes before high courts and Supreme Court always rests on the interpretation of paragraph 2 of the Constitution of India. These are the provisions of the anti-defection law under the Constitution. Now, you have now understood what are the grounds for defection. When defection does not apply, who will decide the applications filed for disqualification? That is the Speaker of the House. Now, you also came to know that judicial review being the basic feature. Therefore, any decision made by the Speaker of the House can be reviewed by the constitutional courts. The power of the high courts under 226 and 227 cannot be taken over. And similarly, the power of the Supreme Court under Article 32, the power of the Supreme Court to decide a matter under Article 136 of the Constitution being a special leave jurisdiction cannot be taken over. Therefore, whether the disqualification application decided by the Speaker, judicial review is always available under 226 and 227 before the High Court. Similarly, under 136 of the Constitution before the Supreme Court. Now, this is the law. Now, after the law has come into force, the next question which you may ask me is whether anti-defection law has curtailed defections. Correct? Whether it has curtailed defections. Now, the answer to this question is definitely no. Now, there exist a lot of loopholes in the law. From time to time, I tell you, successive governments, irrespective of whether it is Congress government, BJP government, whichever, they have tried their best to make the anti-defection law stringent in nature over a period of time. Now, so for example, if you look into paragraph 3 of the anti-defection law, made it very clear that if 1/3 of the members of a political party form a separate group, it does not constitute defection, and therefore it is an exception to disqualification under paragraph 2 as mentioned. Now, this paragraph 3 was completely removed by bringing an amendment in the year 2003. So, with effect from 2004, paragraph 3 does not apply. Therefore, if 1/3 of the members still form a separate group, still it attracts a defection and they can be disqualified. Now, you may ask me a question. People, after getting elected from one political party, join another political party, correct, on the ground of, enjoying as, being sworn in as a cabinet minister. They may be made ministers. Sir, then whether it attracts defection. Now, therefore, remember, the law was made stringent. I tell you earlier, there was no restriction. If at all there are, say, for example, in general, I'm saying, if at all, say, for example, there are 224 total seats in a house, correct? And the government majority now present, there is a law that it should not exceed 15% of the total strength of the legislature. Say, for example, in Karnataka, there are 224 assembly seats, then maximum council of ministers cannot be more than 15%. Means to say 34 cabinet ministers can be there, including the chief minister. But earlier, this was also amended, and 91st Amendment Act 2003 curtailed that the strength of the House, Cabinet, the Council of Ministers in a government should not be exceeding 15% of the total strength of the members. So therefore, this also curtailed. Therefore, everyone cannot be made a minister. Now there is a limitation prescribed, 15%. Therefore, they have to adhere to that. They cannot exceed this strength. Now, similarly, see, these are certain amendments which are brought from time to time. First, they removed splits. Second, they brought amendment by saying that you cannot have more ministers in your cabinet, not exceeding 15%. Therefore, amendments have been made from time to time. But as all of you know, law is for the society. Now, therefore, you have to make sure that laws are amended from time to time. Now, where are the loopholes in this particular law? Now, let me highlight the loopholes of this particular law. Now, paragraph 6 of the law said that you will be filing a application before the speaker for disqualification. Such and such person should be disqualified because of this particular reason. You may give an application to the speaker. Now, what will the speaker do? The speaker, being a quasi-judicial authority, when he is deciding applications, should immediately issue notice to the other side. But there are instances where the speaker has not taken up the application for disposing of, even after 2 years after filing the application. There is no time-bound frame prescribed under the law within which the speaker has to decide the disqualification. Correct? Therefore, speakers keep on delaying and deciding on disqualification matters because there is no time frame fixed, as a result of which by the time the totals, the time frame of that particular legislature comes to an end, then automatically the matter becomes infructuous and it will be of no use to pursue it further because the term gets over. Now, therefore, what are the recommendations to make the law very stringent? There should be a proper time-bound frame. Now, let me give you one particular case law to make you understand. In short form, I will tell you because of paucity of time. Now, say for example, in Karnataka in the year 2010, as I made it very clear, I don't belong to any political party. As a constitutional teacher, I am telling you certain examples. Now, in 2010, you know the political scenario in Karnataka, vote of confidence had to be proved by Shri B.S. Yediyurappa in the Karnataka Legislative Assembly. Now, 11 members of the BJP met the governor, then governor, and said that they have withdrawn support to this government. Now, you have won on a political party ticket of the BJP, and its own members who had won after elections, after a period of time, go to the governor and say, we don't have faith in this government. The government was doing a lot of corruption, nepotism, whatever it is. They gave certain grounds and it over petitions to the governor. Now, as a constitutional authority, when persons go to the governor, when the elected representatives meet the governor and say that they have withdrawn support to the government, it is the duty of the constitutional authority, the governor being the constitutional head of the state, to immediately ask the chief minister to prove majority in the legislative assembly. There exists a reason for doubt. So please prove your majority. So the governor directed Shri B.S. Yediyurappa to prove majority inside the house. Now, these 11 BJP MLAs who were their own party members, who withdrew support to the government, whether their conduct amounts to defection. See, when people do vote, they may look at the political party and vote. They may look at the candidate and vote. Or it may be both, we do not know the mindset. Therefore, whether the conduct of these 11 BJP MLAs withdrawing support to their own government constitutes voluntarily giving up membership of the house. Therefore, a complaint was filed by Yediyurappa to the speaker. The speaker issued notice to the 11 BJP MLAs and independent MLAs, 5 independent MLAs against whom the complaint was also filed, that being co-members of the Bharatiya Janata Party, they have withdrawn support to my government and they have signed in the registers as co-members. That was the argument which was made by the Supreme Court at a later point of time. So what I am trying to say to you people is the conduct of members after winning elections, saying I am withdrawing support to my own government. See, another political party withdrawing support to an outside support given by another political party, withdrawing is a totally different matter. But being MLAs of the same party, you withdraw support to your own government, then whether it amounts to defection. Now, a complaint was filed before the speaker. The speaker issued notices to all the 11 MLAs and the 5 independent members. And as you know, later these 11 BJP MLAs says, we are withdrawing support only to Shri B.S. Yediyurappa, but we are still with the BJP. We are ready to support any government other than Shri B.S. Yediyurappa, any other leader of the BJP. Now tell me, out of 224 assembly seats, correct, if 112 is the majority mark, all 110 of them says we are favoring this particular legislature party leader to take oath as CM, and 2-3 people say we are withdrawing support. When you are won on a political party ticket, you have to be loyal to the political party, which the High Court said, and as a result of which it said, withdrawing support to your own government is attracting disqualification because you have voluntarily given up the membership of the House, which can be implied that you wanted to topple the government and bring down the government. Therefore, as a result, you are attracting disqualification under paragraph 2(1)(a) of the Constitution of India. Now, the MLA said, we are withdrawing support only to this leader, but any other leader elected by the government, we have no problem. But only 11 MLA says you appoint another leader, majority MLAs want the same leader. Now, how to solve this issue? Therefore, paragraph 2(1)(a) clearly made ground that voluntarily given up membership, as the Supreme Court decided in Ravi Nayak case, that voluntarily giving up membership can be judged based on the person's conduct, behavior. The voluntarily giving up membership need not be expressly mentioned, it can be implied by his conduct. Correct. Now, the instances where speaker will not look into the disqualification application filed, there is no time bound frame within which the matter has to be decided. Now, even after the speaker decides, for example, after 6 months, 1 year, whatever the time may be, until the speaker decides the matter, correct? As you all know, judicial review at that particular stage is not available. The speaker should take a decision and then judicial review is always available. But by that time, the legal tussle is solved up before High Courts and Supreme Court. It takes long period of time. Say, for example, a person is disqualified by the speaker. Now, his constituency is not represented. Once a person is disqualified, automatically the seat becomes vacant. Now, the problems of the people of that particular constituency, when the seat becomes vacant, who has to raise these questions inside the House? Who has to bring the problems of that particular people of that constituency? Therefore, the constituency, when it becomes vacant, there is no political representative. In majority cases, up to a year, the legal tussle keeps on happening before High Courts and Supreme Court. So what should the people do? Is it not injustice? Therefore, the law needs to be amended. Now, let me tell you in one instance what happened. Now, in Manipur, if you look into it, a disqualification petition was filed immediately after the elections. Immediately after the elections in government formation, a MLA belonging to the Congress. I repeat once again, I don't belong to any political party. I'm giving you example as a constitutional teacher. Now, a MLA who had won on a Congress party ticket joined the BJP government in Manipur. Now, as all of you know, when a person who has won on a Congress ticket joins BJP government and becomes a minister in the government, but he has won on a Congress ticket, it is a clear case of defection. A petition was filed by the Congress before the speaker to disqualify him under the anti-defection law. The speaker did not look into the disqualification petition for 8 months. After 8 months, the speaker issued notice and kept on adjourning the matter, without deciding the issue. Now, petition was filed before the Supreme Court saying, see, this is a clear case of defection, but the speaker is taking more time. Now, the speaker in this particular case, in the case of Manipur, recently, 2 years before, the Supreme Court said, you decide the disqualification petition pending in your office within 4 weeks from today. After 4 weeks, the Speaker office made a submission before the court that they need another 4 weeks to decide the matter. After another 4 weeks, the Speaker office said, the Speaker has already started up looking into the petition. So he needs some more time to decide the matter. Now the Supreme Court, I tell you, in this particular case, exercised its power under Article 142 of the Constitution to do complete justice in a case. To do complete justice in a case, the Supreme Court made it very clear that until you decide the petition, the person who was enjoying the office of the minister was told not to enter the assembly until the Speaker decides the matter. And the Supreme Court went ahead and said, no need to mention until the matter is tabled up and taken up and the decision on the disqualification is made by the Speaker. He will not continue as a council of the cabinet minister in the government. Now, therefore, I tell you, the Supreme Court in some of the cases has utilized its power under Article 142 of the Constitution to do complete justice in a case. But lots of loopholes in the law have to be plugged in. It has to be corrected. Now, therefore, my sincere suggestion and recommendation that how to make the anti-defection law more stringent and workable for better working of democracy, because democratic institutions are all a temple of democracy. Democratic institutions should behave in such a way that the people should treat it as a temple. Therefore, the findings in the present law, I am saying, the power of Speaker or Chairman to decide questions. Okay, even though the Speaker should decide, there is no doubt, there is nothing wrong in Speaker deciding the matter, but at the same time, the dignity of such high office has to be maintained by behaving in a proper manner, and a proper conduct should be made. Now, the law speaks about anti-defection, but the word defection, what is defection? What I told you was from the dictionary what defection is, but defection is not defined in the present law. Now, there are provisions which encourages merger. On one side, if one person after winning on a political ticket joins another political party, you will say that it constitutes defection. But multiple defections are encouraged by by paragraph 4, which encourages merger. If 2/3 of the members come together, it does not constitute defection. Therefore, minimum 2/3 members have to. They are they will be busy in forming government. In such cases, they try to get a majority by making these 2/3 members of one political party form a separate group, break from that political party and support the government formation. Therefore, that has to be strengthened. Now, what is the provision with respect to the expelled members? You may be knowing about the case of Amar Singh and Jayaprada. Now, if I speak against my own political party, but what I'm speaking is truth. Say, for example, I am not happy with the way the party political affairs are carried on by the president of that political party. I want the party's ideologies to be strongly followed up. I'm not happy with the way they're functioning. One member may make some kind of comments, or his behavior may not be conducive to the political party. In such cases, as all of you know, he will be expelled from the political party. The expulsion will go for 6 years. But he will continue. If he is an elected member, he continues to be a member of the party, but he is expelled from the party. Now, whether anti-defection law should apply to such members? Correct. The law is still silent with respect to this. Now, absence of clear definition of what is political party definition is not the interpretation is to be made clearly. Now, there is an absence of time frame to dispose of disqualification petitions. There should be a time frame within which the speaker should decide the matter. The next is, what is the position of unattached members? Unattached members means, say, for example, there is a party with just 5 members. Correct. 3 members join another political party by 2/3 majority. They become a separate group and they support another political party, merge with another political party. There is only 1 member of the political party. The political party also got merged with another political party. Now, 1 member who does not want to go against the party ideology remains unattached and becomes individual. Now, what is the status of such person? Therefore, there are certain flaws in the defection rules. The defection rules, because on each state legislature it is different, because it's a subordinate legislation. Unless you make the defection rules uniform, these flaws in the law made by with respect to rules of parliament, rules of the state legislature, assemblies of various states are different. So there should be a time frame with respect to deciding on the disqualification petition. There is no time limit prescribed for the committee under defection rules to conduct preliminary inquiry. Now, therefore, all these have to be, these flaws have to be correctly looked in, bring in certain amendments should be brought, and finally, the law commission should study all those reports and come up with a stringent anti-defection law. Now, many times the issue was raised was whether independent judicial commission is required, because speaker may not be an expert legal member. He is a member of the house. Generally, as all of you know, a seniority person of a political party will be made as the speaker of the house. But he may also lack legal language because a lot of interpretations have to be done under the law. Therefore, is it necessary to have the judicial commission, independent judicial commission, to decide on disqualification petitions? Because remember, a member of any political party is elected by the people. The wishes of the people have to be respected. At the same time, I tell you, the wishes of the people have to be respected, but if any wrong decision is taken by the speaker, and later on the court may turn it on, set aside the decision taken by the speaker. But what about the time for 1 year, 1.5 years, where the constituency does not have an elected representative? So these are very important questions to be looked in. So, and this is nowadays, as all of you know, now a trend is people put resignations, resign as members of the house, and then become ministers, and then go for elections after 6 months. Now, this is the recent trend. Now, how to make the anti-defection law more stringent is even people, elected representatives who have won on a political parties, the day their resignations are accepted, in that particular term of the legislature, he should not contest election of that particular term. You are not only the public exchequer for conducting elections is wasted, the time, the crucial important time, and people voices are shut down. People vote a political party, maybe that particular member will do a lot of good work. But after winning elections, if he gets sold for money, power, lure of office, power, position, and join another political party, ultimately it is fraud made to the people as well. Not in all cases, but in certain cases. Therefore, my sincere suggestions is the anti-defection law should be made very stringent by bringing in certain changes. If the speaker decides the disqualification petition, generally it gives room for various allegations that the speaker did not do it very clearly. We did it with a modified intention, all those. Therefore, it is better that an independent judicial commission is established, which takes care of all disqualification petitions from various houses, so that the decision should come soon and the people should benefit. Now, I have, due to paucity of time, it's already 12:10, so I am ending up my guest lecture, but open for questions for the next 10 minutes. I have no problem to answer all your questions. Open up for questions, please.
Thank you, sir. Participants can use the chat box for asking questions. I think sir has explained in detail about the probable questions also. That is what our students are finding difficulty in posing questions also, because it was well explained. Sir.
Thank you. Thank you.
Now I request our principal sir to deliver his presidential address.
Yes, sir.
There's no questions. I'm going to discuss a few aspects discussed by our honorable resource person on the topic anti-defection. No doubt, the 10th schedule included in the year 1985 brought several changes in the democratic setting. As defections were known in different names, that is floor crossing, carpet crossing, house crossing, in different countries, Canada, America, and England. In order to avoid the horse trading after the election is over, when the stable government is in power, to protect the democracy, the Anti-Defection Act was enacted through 52nd Amendment in the year 1985, which clearly stated that if any person elected in a general election by representing a political party, he has to be with the political party. Just because his personal, some reason, he should not change the political party. After 1985, there are a lot of changes which made the government to amend the act once again in the 91st Constitutional Amendment to Act 2003. A beautiful concept was also introduced, that is 2/3 of members of one party have in favor of merger. It not attack the anti-defection law. No doubt, as rightly observed by the source person, it's not questionable before the court of law. If you move on to literal interpretation. But in the case of Kyoto Holono versus Judicial in the year 1992, Honorable Supreme Court held that judicial review is a basic structure of the Indian Constitution. Whatever the decisions of any person who constituted or appointed under Indian Constitution is subject to judicial review. Hence, even a speaker decision is subject to judicial review. Nowadays, the decision of the speaker relating to anti-defection can be questionable before High Court or Supreme Court. There are several cases wherein which the Supreme Court directed the speaker to act in a democratic manner to protect the democracy, even though the anti-defection law has given an ample of power to the speakers. The court clearly held that the quasi-judicial authority should act judiciously. Even few committees were constituted. Take for example, Dinesh Goswami Committee. Dinesh Goswami Committee recommends relating, given a few recommendations relating to disqualification. Recommendation include that disqualification should be only for cases such as member giving up membership of his political party voluntarily, member voting, abstaining from voting, opposed to political party decision. The two important suggestions. The same manner, in the year 1999, Law Commission has given a report in its 117th report. The observation of the Law Commission is delete the exception in case of a split and mergers. Consider the pre-poll electoral fronts as one party under 10th schedule. Party should issue whip only on critical situation or votes. Why that recommendation was given? The Law Commission clearly held that a person elected in the election, he should exercise his freedom of speech and expression in the floor of house, who is representing the public freely. Just because of a whip given by the political party, he should go against the public will. That's why that recommendation was given by Honorable Law Commission in its 117th report. Even the Election Commission has given a recommendation. Is make the president and governor the decision maker with respect to the disqualification subject to binding advice from Election Commission, and the lines of a disqualification based on the Representation of People's Act provision regarding Office of Profit. As rightly observed by the resource person, yes, it's a need of the hour to think and rethink on the provisions of anti-defection law. Today's webinar is a beginning wherein which the participants should think on relooking, doing more research on the on the topic anti-defection law. Sir, on behalf of Soundarya Education Trust, on behalf of Soundarya College of Law, on behalf of all the persons who are present today, I wholeheartedly thanks for accepting our invitation and delivering a wonderful, resourceful thoughts, thought-provoking speech. Sure, sir. Participants will take the information which you given as a part of their preliminary research. They will do research and they'll come with a good research articles and presentation in future days. Once again, let me to thank my coordinator, Anmante sir, who has taken a task of conducting a beautiful webinar. Also thank all my faculties, who always my strength, my students, and my our institution CEO, always a person supporting these beautiful activities in the institutions. Also thank all the person directly, indirectly supported this event. A special thanks to our IT team, always supporting us in conducting events like this. Thank you. Thanks once again.
I thank our beloved principal, Dr. P.P. Mahesh, sir, for his presidential address as well as word of thanks. I thank you, sir. I thank the resource person for today, Dr. OMPRAKASH, Principal in Charge and Associate Professor of Ramaiah College of Law, who have given us a brainstorming information related to anti-defection class. Thank you, sir, for accepting our invitation. On behalf of the management, I extend my wholehearted thanks for your cordial support, sir. I thanks all the participants who have attended this webinar and made this a great event. I request all the participants to share their feedback through the links. Thank you, all of you.
Thank you. I express my sincere gratitude to all of Soundarya College of Law, BP Mahesh, Principal, Soundarya College of Law, Numante Gowda, Co-Coordinator, Soundarya College of Law, and all its team. Thank you for the opportunity. Thank you, one and all.